When we are talking about essential functions, what does that mean? It means that these are fundamental, central to the job, and it is absolutely of the highest priority, basically, for all intents and purposes, that it is not marginal or unnecessary, or it's not something that somebody else could easily do. And here's a great example, a file clerk, right? File clerk's primary essential function is to file things in proper files, right? So someone with a back injury could do a filing job very easily, pulling files and refiling files. One of the things, there was an interesting case where an individual had a back injury and he was a file clerk, and the one thing that he had to do was to pull files that were old and to put them in a file so he could archive them in a particular area so that they could always go back to them if they needed them, but you have to cull the files every once in a while, particularly when you are maintaining a lot of files. And so what he did was he would pull the files, he would put them in a box, and then before he had a back injury, he basically took the boxes and he put them on the shelf in a storage area. And basically, um, uh, the company said, well, you can't put those boxes on the shelf anymore, so therefore you can't perform the essential function of the job. And they fired him. And they basically, the courts basically found that that was not true. Putting the box on the shelf was not an essential function of his job. Pulling the files, filing them, maintaining the files, that was fine. He could even put them all in a box. The challenge was he needed somebody to simply lift them and put them on the shelf. And a file clerk, a mail clerk, right, could help with that. Anybody, could help with putting those files up on a shelf properly so they would be put into storage properly. So um, that's a great example of a marginal activity that the company tried to make the case that it was a fundamental activity, and it was not. So doing good job analysis and having really good solid job descriptions helps us to differentiate between a fundamental central part of the task for somebody to do in their job versus a marginal task that someone could very readily on a rare occasion do to help that person finish that job. It really determines whether removing the function fundamentally changes the job. Having somebody else put a box of files in storage doesn't fundamentally change 95, 99% of what that individual did on the job. Attendance issues, that depends. I mean, as we've learned more, people can work remotely, as we've learned this under COVID. So given, if people are able to work more remotely to do things, saying that someone has to be at work may not be an argument that can be made. So it'll be very interesting to see, how companies start thinking about what is a reasonable accommodation when it comes to this idea of being able to work remotely. The ADA versus Title VII, the concept of essential functions, but the Title VII doesn't make any distinctions in essentiality in analysis of qualifications. So it just says, are they qualified? Right? And how that's to qualify, how that's defined assumes, I think, that in my mind, it assumes that they can do most of the functions of the job or can be trained on those functions once they are on the job, versus the ADA thinks about it a little bit differently, and they determine what is considered fundamental or essential versus marginal or unnecessary. A reasonable accommodation is um, basically any accommodation to an individual's disability does not place an undue burden or an undue hardship on the employer. The goal really is to just remove an unnecessary restriction or an unnecessary barrier. Reasonableness obviously is very similar to those, and when we think about a reasonable accommodation for religious conflicts, right? But the standard is substantially higher. So it has a similar tone, similar expectation, but the standards are a lot higher with respect to what we would accommodate for someone with a disability versus the accommodation we would make for a religious conflict. Each case is determined by particular job duties, and it's impacted by the employee's or the applicant's particular disability. Again, unique to the job, unique to the employee or the applicant. Every case has to be individually assessed. It's very difficult to have a one-size-fits-all policy for adhering to ADA because disabilities are very unique and personal to each person. We have to be clear that a reasonable accommodation doesn't have to be the best accommodation. It doesn't have to be the optimal accommodation. It has to be reasonable. So we always are balancing cost and impact and training and all sorts of different things when we're debating whether or not something is reasonable. The Department of Labor has online resources that can help us with determining possibilities. We see this in Exhibit 1310. But what is the cost? What is the cost for us to accommodate? What is the cost for us to train? The time involved in training, all sorts of factors to consider. A disabled employee entitled to reassignment consideration if qualified to fill a vacant position, even if they can no longer perform the essential functions of a current position. So there is no guarantee of placement, but and that's what the Brown versus Milwaukee Board of School Directors said. The school district doesn't need to promote an assistant principal to accommodate their disability. So we certainly aren't going to promote somebody if they can't do the essential functions of their job. We might be able to reassign them. We have to figure out if there's a reassignment that can work, but there's no obligation to promote somebody to accommodate that disability. Here in Exhibit 13.11, these are the factors to consider when we're determining undue hardship. For example, context, extensive, substantial, or disruptive accommodation if it is extensive, if it is substantial, if it is disruptive. Whether or not the accommodation fundamentally alters the nature of the operation of the business. And that's not what we want, right? These are considered undue if it really substantially, disrupts what we do. The mail clerk needing somebody the file clerk needing somebody to put their, box on a shelf is not considered undue hardship. It's not fundamentally altering the nature of their job or fundamentally altering the way that the company does business. It simply asks somebody to include that as part of their job requirements to once a month or whatever when they cull the slides, when they cull the files, to be able to put them on a shelf somewhere. So, reading 13.11, what are the factors in undue hardship? The nature and cost of the accommodation, taking into account the consideration of the availability of tax credits and deductions or outside funding. The overall financial resources of the facility or the facilities involved, and the number of people employed, et cetera, et cetera. The overall financial resources of the covered entity, the overall size of the covered entity with respect to the number of its employees, et cetera, et cetera. The type of operation or operations of the entity, including the composition, structure, and functions of the workforce. The impact of the accommodation upon the operation of the facility, including the impact on the ability of other employees to perform their duties and the impact of the facility's ability to conduct business. The reasonable accommodation and the contingent worker. A staffing firm and the client are both responsible for a reasonable accommodation. There are tax incentives for eligible small businesses to cover the costs for reasonable accommodations. It helps improve workplace access. It provides deductions for removing architectural or transportation barriers, and it assists in the hiring of vocational rehab referrals. And so the temporary workers, contingent workers, may not feel like they can be accommodated, and hence it becomes a disincentive for them to go out and look for work, even temporary work. So the goal is that the Americans with Disabilities Act, makes staffing firms and clients both responsible for making a reasonable accommodation by creating tax incentives to make it work for them. And this is good practice, because if I can get a tax incentive to help the accommodation, particularly as a small business, this is much better off for me. So where does the burden of proof fall? Similar to Title VII disparate treatment, the employee must present their prima facie case first. Once they determine that, then the employer may defend itself based on a legitimate, non-discriminatory reason, an LNDR, for the employment action. Once the employer meets the requirements, the analysis then shifts back to the employee to discuss if they believe that there was a pretext involved. There is some conflict among the courts, the circuit courts, regarding how mixed motives might play a role here, or the but for, similar to the age discrimination cases, and you have to figure that out circuit by circuit what the precedent is set. So depending on where you're at, what circuit is in place, you'd have to look at what the standards are and what the precedent has been. Ferrari versus Ford Motor Company is, again, an example that we can fall back on. So when somebody requests an accommodation and the employer responds, there is a process that we have to go through. The EEOC assists employers regarding the EEOC's and the court's perceptions and expectations about the employment of disabled individuals. So the employee must provide notice of the non-obvious disability and any limitations, and therefore request the reasonable accommodation. And note that we said employee here, not applicant. An applicant is not obligated to divulge a non-obvious disability to the employer until they have a job offer in hand and they have been hired. In which case then at that point they can reveal what their disability is and what accommodations that they will need. There are some lenient interpretations of these requests. A prompt response is required. It's usually an interactive discussion. The third-party assistance could be offered if need be, like so having a mediator help you with that discussion. But the bottom line is the employee asks for the accommodation. We determine whether or not it's something that we can reasonably do. And then that reasonable accommodation is documented and fulfilled, assuming that it's approved. It does require the employee to cooperate just as it requires the employer to cooperate, right? The expectation is that both parties are going to try to figure out the best option for all parties involved. And it doesn't mean that it has to be the pinnacle accommodation that the employee wants. It could be something a little bit different, as long as it helps them to be able to do their job. The key is about the interactive process. Both the employee and the employer really must work together to identify what the reasonable accommodation is, what the range of reasonable accommodations would be that would be needed, what's the minimum that would be needed by the employee to be able to do their job, do the essential functions of that job. The burden is on the employee to request the accommodation. The employer cannot read their mind, and particularly if it's a non-obvious disability, it is important for the employee to make the case for what they need and why. So how does this interaction work? The employer meets with the worker and they obtain as much information they can about the individual's conditions, what the expectations are, what the limitations might be for them. They talk about the range of alternatives. They consider the accommodations, and the expectation is through negotiation that they document what they need and they move forward from there. Employers have a right to request medical documentation of disability. So if you say you have a disability but you've not gone to a doctor to have it documented, that's going to be problematic. So you do need to have it documented by a doctor or some sort of medical professional, whatever that might be, and to have that then go back to the employer. It may be great if we could take everybody's word for it, but that's not the case. And so if you want to have your disability accommodated, you've got to have documentation about what it is, what the limitations are, and have it documented by a medical professional.